This is Speaking Freely with the ACLU of Pennsylvania. I'm Andy Hoover, your host and Director of Communications at the ACLU of PA. Our voting rights work in 2024 is multifaceted. ACLU-PA is engaged in organizing and mobilizing work at the county level to advocate for pro-voter policies. We're doing a lot of voter outreach to make sure that voters know their rights and know where to go if they have trouble voting. And by the way, if that's you, call 866-OUR-VOTE to reach the Election Protection Hotline. You can get assistance from ACLU-PA and our allies. An additional prong of that work is our legal strategy. Here in 2024, ACLU-PA and our partners at National ACLU and the Public Interest Law Center have taken a different approach than in past election cycles. This year, we've implemented a proactive strategy to make sure that voters who want to cast a ballot can do so without unnecessary hurdles. Here to talk about it is Vic Walczak, Legal Director of the ACLU of Pennsylvania. Our conversation was recorded on October 3rd, which is noteworthy because by the time you listen to this, it's possible that we will have new rulings in the cases that Vic and I discuss. To get the latest updates, go to aclupa.org/litigation and click the drop-down box to choose voting rights. Well, Vic, welcome back to the podcast, and you are talking today with me about a very timely issue, and that is the state of our legal strategy on voting rights for this 2024 election cycle. And I want to ask you about the current cases. But before we get there, let's set the stage by talking strategy and rewinding to 2020 because our approach this year changed. How did ACLU-PA approach its legal strategy in the last presidential election cycle?
Okay. So thank you, first of all, for covering this and having me on. So I actually want to wind all the way back to about 2008 because our strategy going into 2020 was pretty much a continuation of what we've been doing for multiple election cycles. So since 2008, we at the ACLU have been manning what's called the Command Center as part of a nationwide nonpartisan voter protection effort called 1-866-OUR-VOTE. Includes a database. It's administered by our friends at the Lawyers Committee for Civil Rights. Lots and lots of our allies, good government groups, get out the vote groups are involved in all aspects of this. But what we at the ACLU, the unique role we had is that we largely took care of any sort of serious problems voters were having getting access to the ballot box. And just to be super clear, this is not complicated, right? What our goals are, and voting should not be as complicated as it is. But our goals are super simple. They have not changed in decades, and certainly not today. And that is that every eligible voter who wants to cast a ballot should be able to do so safely, securely, and conveniently. And then the second part of that is that every eligible voter should have their ballot counted, right? Very, very simple, nonpartisan. We never ask any voter what party they're registered with, what candidates they're supporting. I mean, we are completely political blind in terms of trying to help people. And in every election, I mean, between the hotline that the Lawyers Committee runs and the legal efforts that we do, hundreds, if not thousands of voters are helped. Again, I want to make sure folks know this number because it's important. If you need it or a friend or family member is having problems in any aspect of trying to vote, and it's 1-866-OUR-VOTE. It's already being manned now in early October because of early voting. So we've been doing that since 2008. And what does that mean on the legal side? Really, what we've done is recruited local lawyers in most counties around Pennsylvania so that if there is a problem on election day, we can send them in to take care of it. So problems could be machines broke down, really long lines, and they need to keep the polls open longer because people were disenfranchised. You've got a judge of elections who's asking everybody for photo ID when the rule is only first-time voters have to present some kind of ID and it's not photo, right? And to the extent we can't fix those problems with a call to the elections office or the solicitor, which is always the first step, then we can send lawyers into court. We typically go into court a handful of times every election day. That's what we've been doing since 2008. That was the plan for 2020. Really no different. But a number of things happened in 2020, some of them not so good, that really kind of altered the landscape. So the first one actually happened in November of 2019, and that is the first significant amendment of Pennsylvania's election code in a very long time. And the important change that a bipartisan group of legislators supported, Governor Wolf signed, was what's called no excuse mail voting. We've had absentee voting in Pennsylvania forever, but that was limited to people who essentially had a doctor's note or could affirm that they're going to be out of town for business or school, right? So it wasn't anybody could do it. The change in 2019 was, you know what? Like a lot of states that allow anybody who wants to vote by mail, that's what we're going to do in Pennsylvania. Great change, makes it much easier. So, but the first time that mail voting was going to be tried was in 2020. And then, I will remind people, although I'm sure I don't have to, that in March of 2020, we got hit with the COVID pandemic, right? Upended our lives in ways that none of us could have foreseen, which made mail voting that much more attractive, right? If you think back to those days, didn't know, could you go out? Were you able to go to the polling place? Was it dangerous, right? And to be able to simply vote by mail and never have to go and interact with other people was really, really attractive. So then the third thing that happened is that even though the no excuse voting was supported by both parties by good sized numbers, in the spring of 2020, presidential candidate and then President Donald Trump decided to malign mail voting and say that it's just ripe with all sorts of problems. And so it was at that point that one of our political parties began demonizing mail voting. And in June of that year, the Trump campaign filed its first lawsuit, I believe in the country. It was filed in federal court in Pittsburgh, where I happen to live. And it went directly after mail voting. They said that, you county government, state government are not allowed to do anything to make mail voting easier. So you can't have drop boxes, you can't have satellite offices, can't have extra hours. And the battle was on. And by election day, there were probably already a dozen lawsuits filed, mostly by the GOP, challenging different aspects of mail voting, trying to make it a lot harder. So that was something different. That was not something that we had seen before 2020, was the sort of aggressive use of litigation to try to undermine voting. I mean, we had voter ID, right, which we challenged successfully back in 2012. There were some other problems, but this was really a much more systemic attack on a certain aspect of voting, mail voting, which at the time was new. So, all of those things coming together really changed our strategy for this year. Now, I think we did pretty well in 2020. I'll just let me just say that we at the in 2020 and again now, I mean we've joined with National ACLU's Voting Rights Project with our longtime colleagues at another public interest organization at Pennsylvania, the Public Interest Law Center. Can't say enough about how fantastic they are, both as lawyers and as colleagues. And then we bring in law firms who provide pro bono assistance. And, you know, we kind of got through 2020, but it wasn't because we had it all systematically planned. And there's actually one other really big difference that kind of set the stage for what's going on in 2024.
Okay, you're gonna leave me hanging there on what that big difference is, but I want to be clear about 2020, which is the our team, ACLU-PA, ACLU Public Interest Law Center, got involved in those lawsuits as what's known as interveners. So we were not actively bringing litigation. We were being responsive to the political parties, which brought a variety of lawsuits. And in fact, there were at least one occasion where the Democrats also brought litigation to try to get some clarity around election law. So we're talking about a change from public interest nonprofit groups like ours reacting to this cycle where we are taking a more proactive approach.
Right.
Before we go there, do you want to say that one other thing that that was
Yeah,
important?
yeah. But just let me follow up on the point you made, which is a really good one. That in many of these cases, we were always defensive. We were on the side of the government, which was defending the ability to make it more convenient for voters to vote by mail. And we represented a bunch of good government, get out the vote groups, you know, NAACP, League of Women Voters, Common Cause, Power, Make the Road, Casa San Jose, Black Political Empowerment Project. So these are all groups who were our clients, who are all trying to help voters vote. And we were able to present sort of the classic voters' interests, right? Not through a partisan lens, right? Because the parties are looking at it whether or not this is going to help them. Right. The only thing we're looking at is from a pure voting rights perspective, which is whether or not this interferes with the voter's ability to cast a ballot and have that ballot counted. The big, you know, the big change that I'm sure we'll talk about in a little bit was that before the election in 2020, there was lots of rumors about efforts to overturn the election, to allege that there was fraud, allege that there were problems, and that you have to flip who won, right? And you know, before that, we'd never really thought about certification deadlines. Those are when the counties have to certify that they finished counting and it's accurate. Then the state has to certify that, and then it goes to Congress, and Congress has to ratify the results. And you know, we thought that was all nonsense, and now we know that it wasn't. Right? Just the efforts to overturn the election, to take the vote away from the people, right? The will of the people. I mean, it's whoever gets the most votes, at least in the Electoral College for president, wins. And for the first time, certainly in my lifetime, that was different. And while we had heard about it, we honestly didn't believe it was going to happen. And I can't say we were prepared. And I, you know, admittedly, I think we were on our heels the entire time. We managed to get involved in a lot of those cases. I think we helped in some of those cases. But it was not because it was really planned out and thought through in advance. That was 2020.
And I want to ask you about preparations for after election day, but let's get back to how the legal team decide to approach this election cycle. So you're taking a more proactive approach. Talk about how you came to that conclusion and what that actually looks like.
Yeah. So I think the biggest factor is that because of this sort of unrestricted new form of voting, right, through mail balloting, no excuse mail balloting, anybody can do it. The numbers of people who are taking advantage of that has become a target as a result of the General Assembly being divided, being paralyzed, being unable to fix some of the problems that really need to be fixed because of conflicting and inconsistent court decisions. The system's kind of a mess. And what we've seen, and this comes up to the present, that about 1% to 2% of all mail ballots are disqualified. And so I mean, it's easy to look at that and say, yeah, 1 to 2%, no big deal. But if you take the number of people that are voting by mail, and we don't know how many are going to vote this year, but in 2020 it was about 2.7 million. I think the best guess is it's going to be in that same area again, maybe higher, maybe lower. But if you take 1 to 2% of that as ballots being disqualified, I mean, you're looking at 25 to 55,000 votes being thrown out. And just to be clear, this is not ballots being thrown out because the voter is not eligible to vote. This is not a fraud issue. This is voters who everybody agrees are completely eligible, right? They meet all the criteria. They're U.S. citizens. They've lived here long enough. They're over the age of 18 years old. Their ballots have been returned in a timely way. The only problem is they've made some kind of mistake in returning the ballot, right? This isn't even on the ballot. This is about returning the ballot. And these voters are, if you don't fix the error or if you credit the error, then you're going to have tens of thousands of voters disqualified. And the errors that we're talking about, there's essentially three. One is failure to sign the declaration envelope. So the ballot goes in the secrecy envelope, right? Got to have the secrecy envelope. If you forget that, that's a cause for disqualification. The secrecy envelope goes in an outer, what's called declaration envelope. So it's got a declaration saying you are the voter, you're eligible, etc. You have to sign that envelope and put the date that you're signing it on there. And if you mess up on the secrecy envelope, the date or the signature, your ballot will not count. Now, we looked at that situation after 2020 and were pretty alarmed, did not see fixes coming through the legislature, and so decided in 2022 that we needed to start to address those problems. And I think of them in two categories. One is errors that are completely irrelevant, and the other is errors that are minor, but you got to follow through, but they're fixable, easily fixable. And none of this affects the integrity of elections. And the first category, the ballots that, are the errors that are completely irrelevant, involve the date, right? The only date that matters is when the elections office gets the ballot, right? And they know exactly when they get that ballot, right? They put a hand stamp on it. They got to scan a barcode, unique identifying barcode into the state registration database. The date is completely meaningless as long as the ballot gets there by 8 o'clock on election night. So we've been fighting in a whole series of lawsuits arguing that even if the voter puts no date or gets it wrong, that ballot should automatically count, either under federal civil rights law or under the Pennsylvania Constitution. The other category, which is the errors that are easily fixable, are the signature. Now, you need the signature on there because if you're going to commit fraud, that's kind of what they would rely on. You sign it, say you're that person, but you're not, then you can be prosecuted. Secrecy envelope, the Supreme Court has said is important to maintain the secrecy of the ballot. Other states don't necessarily apply it, but that's the law in Pennsylvania. Those two errors are easily fixable if the voter knows about it and is given an opportunity to fix it. So the other bucket of litigation that we've had starting this year goes to making sure that counties let the voters know that they've returned a mail ballot with a disqualifying error, and then giving them some ability to fix the problem.
And the primary this year, well, first of all, the legal team was starting to gather. I might have my timeline not quite exactly correct, but the legal team was proactively gathering policies from counties. And then the primary election triggered a number of opportunities because we saw the counties in action doing some of the things you're describing. So let's just kind of walk through the cases that are in the pipeline right now, because they address the issues that you're talking about. So can you kind of take us through each of those?
Yeah, so the first one is the date error. That's, the date is irrelevant. So those ballots should automatically count, regardless what the voter writes on the outer envelope. We brought a couple of federal court lawsuits arguing under the Civil Rights Act and the Voting Rights Act that those ballots should automatically count because they are, under the law, an immaterial paperwork error. But for reasons that I won't bore listeners with, we've thus far have lost those cases in federal court, have won a number of rounds, but ultimately that litigation hasn't been successful. So after the primary in April, we filed a lawsuit in the Pennsylvania Commonwealth Court arguing that because the date is completely irrelevant and because of upwards of 10,000 voters were disqualified in 2022, right, which is a midterm election, so it's more than you would have in 2021 or 2023, not nearly as many voters as you're going to have in a presidential election year like 2024. But even in 2022, nearly 11,000 ballots were disqualified because people messed up on the date. And if you sort of multiply that out by the increase in votes this year, it's easily could be well above 10,000 ballots disqualified for the date reason. And we argued for the first time, any lawsuit has argued that under the Pennsylvania Constitution's free and equal elections clause, that you cannot have barriers to voting that are nonsensical, right? You got to have some decent reason for doing this. And in the federal litigation, we did discovery. We got answers from all 67 counties, Department of State. Not a single one could identify a reason for the date. So we filed that case in Commonwealth Court, got a fantastic opinion, case called Black Political Empowerment Project versus Schmidt. And then a couple of weeks ago, the Pennsylvania Supreme Court, for reasons that are still a little difficult to understand, or very difficult for some of us to understand, they vacated that decision, not because they disagreed that it was unconstitutional, but they bought the GOP's argument that the Commonwealth Court did not have jurisdiction to hear that case in the first place. Now, it gets a little complicated beyond there, so I'm not going to get into it. But then just last week or the week before, we filed a brand new case directly with the Pennsylvania Supreme Court under something called their King's Bench authority. So it's really for emergencies that need to be resolved quickly. So we're 5 weeks from the election, so this should fit that. But we raised exactly the issue with them. Do ballots with incorrect or missing dates automatically get counted? And they should under the Pennsylvania Constitution, and we are still waiting to hear whether or not the Pennsylvania Supreme Court will take that up. So that's kind of where the dating issue lies.
So then we have some litigation against a couple of counties, which touch on some of the issues you described. So one of the issues you talked about was the secrecy envelope, and the fact that mail voters have to put their ballot in that secrecy envelope and then put it in the return envelope, the declaration envelope. So let's talk about that, because there is an important fail safe for voters if there is some problem, and this came up in Butler County.
Right. So one of the cases that was decided in 2020 by the Pennsylvania Supreme Court, and then a couple of cases after that, essentially established that notice and cure, right? So for counties to give notice to the voters that there's an error and give them an opportunity to fix that is permissible and optional. Okay. And but it's not, you can't force the counties under the election code to do it, right? So it's a permissive system, and that's the system that we're living with right now. And a map is coming out right about now that we put together based on right to know responses, documenting which counties have which practices. And what we've seen is about 45 of the 67 counties provide some form of notice of a disqualifying error on your return ballot and some opportunity to fix that error.
We just released that this morning, as a matter of fact.
Perfect.
Yeah.
I mean, really invaluable resource. I think it will be for everybody. But that leaves 22 counties that are not doing anything to help their voters. And the thing is that this is not a big lift for counties, right? You've got 45 counties that are doing some variation of both notice and allowing voters to fix problems. And this is what government's supposed to do, right? This should not be a game of gotcha where, you forgot to sign it or you forgot the secrecy envelope. We know it. We could tell you, but we're going to keep it secret so you can't fix it. Right. That's a hostile, unfriendly government. And that's not how things should work. Government should not interfere with people's ability to exercise their fundamental rights. And nothing's more fundamental than the right to vote. So on the back end, because the court has said that we can't mandate curing, right? So curing is, you find out that there's a problem with your ballot, forgot the signature, forgot the secrecy envelope, forgot the date. And many counties will either send you an email, call you, send you a letter, and give you an opportunity to go into the county elections office, or sometimes they have satellite offices they set up close to the election, and fix the problem. Right? This isn't voting multiple times. This is just fixing a problem that is going to prevent your ballot from being counted, right? And that voter will get to vote exactly once, and that's the way it should be. If you don't allow that, then the voter is going to vote exactly 0 times, which is not ideal. So Butler County, we sued Butler County in, I think, May. After the primary, they had a policy that if you mess up the signature or the date, that you can come in and vote what's called a provisional ballot on election day. And so a provisional ballot is something that was required after the 2000 Florida debacle. So Congress passed a law, Help America Vote Act, which essentially said that if a voter comes in to the polling place and there's no record of them being registered or there's some other problem, that person has to be able to vote a provisional ballot. And the reason is, in Florida, they had all sorts of problems with their voter rolls. In 2000, people were showing up We're being told you're not here, you can't vote. Well, if you don't do something on election day, if you don't have some piece of paper in, then you're going to be disenfranchised. There's nothing you can do. Provisional ballots are designed to be a fail-safe. So, if in fact it turns out that you were not registered or there's some other problem, right, your ballot's not going to count. But if it turns out the mistake was made by the government, by the county or the state, then that ballot's going to count. Again, it's all about making sure that all voters, all eligible voters can get to that one vote. Pennsylvania adopted legislation, I think in 2004, implementing provisional ballots. And so it's not a cure. This is not fixing your mail ballot. This is coming in and voting a new fail-safe ballot that will only count if your mail ballot doesn't. In Butler, they were allowing provisionals for missing secrecy envelope and missing signature. I'm sorry, for missing signature and a date error, but not for the secrecy envelope. We filed a lawsuit, Genser versus Butler County. And the Commonwealth Court a few weeks ago agreed with us that voters who make a disqualifying error on their ballot can come in and vote a provisional ballot. And if their mail ballot really is disqualified, the provisional ballot must count. If the mail ballot turns out to be okay, then you throw out the provisional ballot, right? So that's the lawsuit on the back end involving curing.
In that case, the state Supreme Court announced that they are going to take the appeal in that case.
That's correct, and the case is now fully briefed, so we're just waiting for a decision.
Then you have another level of problematic behavior by a county, which is in Washington County. Describe what happened there.
Yeah, so this is the front end of the process involving notice. So we just talked about provisional ballots and being able to fix a problem with your mail ballot, and then other counties allow curing where you can come in and add your signature, or they'll give you a new ballot and you can vote that. Make sure you have the secrecy envelope in there. In Washington County, they were, until April of 2024, until the most recent primary election, Washington County was sending voters who submitted a ballot with a disqualifying error an email saying you made an error, you can come in and fix it, and letting people come in and vote a provisional ballot. In April, a new configuration of county commissioners decided that they did not want any mail ballot voters to be able to fix their errors, right? So if you think about this, it really still kind of blows my mind that anybody would support folks who take this kind of anti-voting position. What they're saying is, we know that your ballot's not going to count. We're the only ones who know because we're looking at it and you've got your signature, right? Or there's no date on there. And we're not going to tell you. So there's no way you're going to be able to fix that ballot. And so they directed the county elections office and the workers there to put in a code, like when the ballot comes in, a code gets entered, so it's listed in the statewide registration database, to put in a code that does not inform voters that they have a disqualifying error. Voter thinks, everything's fine, I don't have to worry. As a result, none of the 259 voters who were disenfranchised in April of 2024 tried to vote a provisional ballot or fix their ballot. And the reason is they didn't know. When we called these voters several weeks after Election Day, they didn't know even then that their ballots hadn't been counted, that they had been disenfranchised. And it was so bad that even if a voter called the office, right, forget the email, forget a phone call, if the voter called the office and said, you know what, I'm just thinking maybe I forgot to sign my ballot, can you check that? They were told no. the ballots are locked up. We can't see them. So in July, I think it's July, sorry, all the days are running together. We sued Washington County, alleging that under constitutional procedural due process, it's fundamental that anytime the government cancels your right, tries to take away any fundamental right, the citizen has a right to get notice of that and some opportunity to contest that decision. And so, based on that very elementary due process principle, that Washington County must give notice to voters in a timely way before Election Day that there's a problem with their ballot. The Court of Common Pleas judge agreed with us. And just, I think it was last week, the Commonwealth Court agreed with us that, once a ballot comes in with a disqualification, the county has to notify the voter that there's a problem with their ballot. The GOP has now asked the Pennsylvania Supreme Court to review that decision, and we are waiting to see what the Pennsylvania Supreme Court does with that. But ideally, that decision would apply to all of those counties that, for no good reason, refuse to notify voters that there's a problem with their ballot, and if they don't do anything, that ballot's going to be thrown out.
So we've described all these cases. They are in the pipeline, at or potentially going to the state Supreme Court. If this strategy works, and we've had some good outcomes so far, but if the strategy works, what will that mean for counties and how they handle mail ballots? What outcome is the best case scenario?
Well, the best case scenario is we win all of our lawsuits, which we think is always the best case
Yes.
scenario. But I think there are. Let's take the three different types of cases. So in many ways, the most important one is the dating error case, because if we win that, then anybody who makes that dating error, and that's about half of all the errors that lead to disqualified ballots, those ballots would automatically count. I mean, you don't have to worry about notifying the voter, them taking any other steps. Those ballots just count because the data is completely irrelevant. And that would apply statewide. Every county would have to count those ballots. And again, as we're looking at the landscape, that's going to be upwards of 10,000 ballots, right? That's a lot of voters. On the notice and the provisional ballot, if we win, what that means is that the 22 counties that don't give any kind of notice to voters that there's a problem and don't give them any opportunity to fix those problems are going to be required to do it. And the nice thing about that is that should reduce the number of voters whose ballots are disqualified. Now, we're not getting to zero, right? I mean, look, mistakes happen. We all make them. I probably made 10 today already, even on this podcast. That I may regret, right? And so people are gonna make errors. One of the things we're seeing that disproportionately these errors are made by older people. Seniors, may have more difficulty navigating new technology, new things, whatever. So some of these people are still going to make errors, but if we have notice and an opportunity to fix those problems, a good number, and what we're seeing is it's anywhere from about 40 to 60% of voters who make an initial error, who are notified of that error, come in and actually correct it so that their ballots count. So this is all just about minimizing the number of eligible voters, right? Now, I stress these are eligible voters, people who have every right to vote and have their vote counted, to minimize the number of these voters who are going to be disenfranchised.
And I know you feel quite strongly about one. I asked you about best case scenario, but I want to bring up one other case that is lingering out there. It may turn into a nothing burger, but you feel quite passionately, and we all do, about this particular case, which is Republican National Committee v. Schmidt, where everything you've just described, the RNC is trying to wipe out. Can you address that?
Yeah. So first of all, let me note that in every single one of the cases that we've been talking about, the primary opposition there is the GOP national and state parties, right? And why they don't want voters' votes to count is really a mystery to me. Ultimately, it doesn't matter. We're all about trying to make sure that voting rights are respected, so every voter can cast a ballot and have that ballot counted. So the numbers that we were throwing out, which is probably 10 to 50,000. I mean, at least 10,000 ballots will be thrown out just for the date alone. When you add in the others, so it's a lot of votes. The RNC filed what's this King's Bench petition with the state Supreme Court, which is what we filed on the dating problem. Both cases are still pending. What the RNC is asking the court to rule is that no county is allowed to do any form of notice and cure, right? And the reason that is so significant is because, like I said, you have 45 counties who are doing it, including all of the largest ones: Philadelphia, Allegheny, Montgomery, Delaware, Bucks. They all help their voters, if they've made an error, fix that error so their ballot can count. If the RNC is successful in that lawsuit, that's going to drive the number of voters who are disenfranchised up dramatically. And I think it is not an exaggeration to say it's going to be at least 50,000 of these mail ballots are going to be thrown out if the RNC prevails. And what's really upsetting to me is that when you look through their hundreds of pages that they filed in that King's Bench application, nowhere in there do they allege that this is necessary as a matter of election integrity or fraud prevention. Their only argument is a hyper-technical statutory language one. They say, hey, the legislature never said you could do it, so counties can't do it. But at the same time, the legislature never said you can't do it. So why would you err on the side of disenfranchising voters? And under the Pennsylvania Constitution, there's hundreds of years of history saying essentially tie goes to the voter, right? Unless there's a good reason to disenfranchise voters, you count the ballot.
And just to be clear, and to add a couple of thoughts to that, one, well, first of all, as the person who just sent the press release, we have 36 counties that do some version of notice and cure, which you described as giving the voter notice that there was an error, giving them the opportunity to correct that particular error so they don't have to vote a provisional ballot. And then there are 10 more that at least notify the voters so they can go vote the provisional ballot. The thing I wanted to make note of is this is not new. This did not start with no excuse mail voting in 2020. Counties have been doing this for decades with absentee voters. When absentee voters have some error, it's going to disqualify them. They have been engaging in this practice. And you mentioned the large counties that have notice and cure. The range of counties in terms of political culture is significant. Yeah, you mentioned Philadelphia, Allegheny, Dauphin just implemented a policy, but it's also Tioga County up north. It's Adams County in the south. Like these are, it is states, or I mean, it's counties that are politically dominated by Democrats and counties that are politically dominated by Republicans. So this is a policy and a practice that people across the spectrum, at least at the local level, have recognized as valuable for voters.
Yeah, I'm just not sure why it's complicated. If you are an elected official in a county, wouldn't you want to do everything you can to help your citizens, the people who elected you, be able to exercise their fundamental right? I mean, I just don't get it, especially because it takes virtually no work to do it the right way and help people.
Right. And just so folks know where we stand in terms of the legal process, at least as we're recording this, and just check out our website for updates. But the state Supreme Court has not said that they're going to take that case, which they have total discretion to do. Either they'll just not take it, which means it's, the RNC will have to figure out their next move, or they will take it and then it will proceed like a lawsuit, although presumably on a very expedited schedule.
Yeah, and here we are 5 weeks out. When we started with all these lawsuits, our stated goal was to have all of this decided by the time voting started, which has really been in the last week, and yet here we are with really none of the cases finalized yet, none of these issues. But I guess it's also not. I guess it was a little bit unrealistic to think that everything would be wrapped up. But time is definitely getting tight, and so there's going to be a lot of pressure on the lawyers to file their briefs very quickly. And there's also going to be a lot of pressure on the Pennsylvania Supreme Court to rule quickly on these, and hopefully they take the time to review carefully and get it right.
So, one last question while I have you here. I have to ask you about what's yet to come. We and our allies anticipate more litigation before, on, and after Election Day. And that may be especially true if the results are not to the liking of one particular candidate in one particular race. How has the legal team been preparing for that?
Yeah, so that's a big change that was informed by what happened in 2020, right? This is the legal term we use is batshit crazy ideas that you can overturn an election, right? And delay certification so that, Congress can overturn the will of the people. I didn't believe that would happen in the United States of America, but it did. And what we're seeing, I mean, we just had a vice presidential debate where one of the candidates refused to say that, they would honor the results of the election. Um, so we now know that past is almost certainly prologue. And again, it's going to depend on the results of the election. I do think if the one candidate loses, we're going to have weeks, if not a couple of months, of robust, acrimonious litigation. I will tell you that I was one of the privileged few to be in court in 2020 in federal court in Williamsport in front of United States District Judge Matthew Brann, in the Trump campaign's lawsuit trying to overturn the election. And they were literally, their ask of the court was to throw out nearly 6 million Pennsylvania votes. And that was the case. Rudy Giuliani showed up. It was about a 6-hour case. It was insane. I mean, there was no argument to justify taking away one vote, much less millions of votes. Judge Brand rejected that argument. It went to on appeal to the Third Circuit, and a Trump-appointed judge rejected that, saying, in this country, it's not enough just to make allegations. You got to come forward with proof, and there ain't none. And that was a Trump-appointed judge who wrote that. So the fact that we've seen that these folks are capable of and willing to go to these extremes means that we have to be prepared. So again, working with our friends at Public Interest Law Center, the Voting Rights Project, we've got several law firms working with us. We are preparing for mass ballot challenges. Who knows what the theory is going to be there, but we're expecting that, one party is going to come in and try to disqualify, probably mostly mail ballots. We're preparing for many recount petitions being filed. Most of those are going to be garbage, but they potentially are going to slow down the process. And the big concern, and I don't think it's a huge concern, but it's something that we are preparing for, is efforts to try to delay Pennsylvania from being able to certify the election, and they have to do that by December 13th. There's lots of and litigation could slow the process down where that becomes an issue. We are preparing. We're going to have lawyers on the ground. We're going to have observers, field investigators out in the counties. We're going to have pre-drafted legal papers to be able to go into court at a moment's notice. So we are preparing. And hopefully, because we do have now some history of these efforts to overturn the election, we will be fully prepared to address them this time. And we're not alone in this, right? We've got the governor's office, the Secretary of State, the Attorney General's office. These are not election deniers, right? Which is good. That's super helpful. I'm cautiously optimistic that we're going to get through this, even if the one candidate happens to lose and tries to overturn the election. But I'm pretty sure it's going to get messy.
Well, Vic, that's very comprehensive. I asked earlier about best case scenarios. Here's hoping for all the best case scenarios to work out. But thanks, thanks for describing all that work. I'm sure our members appreciate it, and thanks for your time.
Yeah, appreciate you, Andy. Thank you.
That's Vic Walczak, Legal Director of the ACLU of Pennsylvania. To stay updated on ACLU-PA's legal work, visit aclupa.org/litigation. And that brings episode 89 to a close. The editor of Speaking Freely is Natalie Montero. Our opening theme is by Moody Finn, and our closing theme is by Elliot. Both are courtesy of bensound.com. The executive director of the ACLU of Pennsylvania is Mike Lee. I'm Andy Hoover. Until next time, be free.